Welcome, everyone, and thank you for joining us. Happy New Year. Hope everyone's off to a great 2025. Just a few housekeeping items before we get started today. Today's session will be an hour with time for Q&A throughout the session. This webinar will be recorded for future viewing. Please note that participation in this webinar qualifies for free CME, and the CME link will be provided at the end of the webinar. Any resources mentioned today during the call will be made available after the presentation. We encourage questions and comments. Please submit those using the chat function. If you would like them to be shared anonymously in the chat, please select to send just to myself or Lindsay Hanlon only, and we'll share it at the end. The presenters today have no financial relationships today to disclose. The webinar is approved for one AMA PRA category of 1 credit. And I'm pleased to introduce our speaker today. Dean McConnell is currently the Deputy General Counsel at COPIC, a medical professional liability in Denver, Colorado. I'm sure many of you are familiar. Before coming to COPIC, Mr. McConnell was a shareholder in the law firm of Kennedy Childs, practicing in the area of healthcare law, insurance, and business counseling from 1989 to 2013. He was born in Denver, Colorado, and received his Bachelor of Science degree in Business Administration and his Juris Doctorate degree from the University of Denver. His private practice primarily involved representation and counseling of healthcare providers and entities on a wide variety of legal issues, including entity organization and formation, sale and dissolution, employment and other contracts and policies, regulatory, HIPAA and antitrust compliance, professional review, privileging and credentialing issues, billing problems, including fraud and abuse, and a variety of healthcare business issues. Mr. McConnell is licensed to practice in the United States Supreme Court, the 1st and 10th Circuit Court of Appeals, the District Court of the District of Colorado, and all Colorado County District and Appeals Courts, appellate courts. Wow. It is my pleasure to introduce you to him today. So take it away, Mr. McConnell.
Well, thank you. As she said, I've pretty much been defending healthcare providers and healthcare entities for my entire career. That is what I have done. It's what I've enjoyed doing. Hopefully you're now seeing my screen. I started out probably for the first 10 years, primarily doing almost exclusively medical malpractice defense cases, or defending medical malpractice cases. So, for the last 12 years, I've been with COPIC and have continued to be, intimately familiar with what's going on in terms of the medical malpractice scene and the variety of states that we practice in. So, let's get started. What is a medical malpractice case? Well, the plaintiff, your patient who's suing you, has to prove basically 5 things. They have to prove that you owed them a duty, that what the standard of care was, that you breached the standard of care, that breach caused damages, and what those damages are. The essence of most medical malpractice cases are really kind of come down to whether there was a deviation from the standard of care and whether that deviation from the standard of care actually caused damages. Now, in most cases, whether there's a duty is well, in all cases, it's determined by the court, but it's usually not much of an issue in most med mal cases. It's long been established that providers in administering treatment to their patient are obligated to exercise that degree of care which a ordinarily prudent physician or healthcare provider would provide under the same or similar circumstances at the time the care was being provided. There are a few times when we do fight over duty. Curbside consults are by far and away the most common. And all of these revolve around whether you actually have developed a physician-patient relationship, because that's really what causes you to have that duty in the first place, is the creation of that physician-patient relationship. And so independent medical exams, sometimes in transplants or genetic testing, it may come up in a few cases, but most of the time, the duty has been established that you have to exercise reasonable care under the circumstances, which is the legal standard of care. what an ordinarily prudent physician or healthcare provider would do under the same or similar circumstances at the time the care was being rendered. It's really not one standard. It's actually usually a range of different acceptable practices is certainly what I've argued repeatedly throughout my entire career. And the way we establish that is we figure out, well, what do physicians or healthcare providers in that same specialty usually do? What are the written standards, whether they're from groups like ACOG or the other American colleges or boards, or what hospital protocols are involved on the particular topic. What were you taught in med school? What does the literature say? And then we introduce all of that information through expert witnesses who will testify whether your care was reasonable or not. Now, you'll be very involved in helping us develop what we believe is the appropriate standard of care in every case. You're our starting point. You are our client. You are an expert. And we will have you do that. And we will also be tapping into you for who you think would be a good expert in terms of that process. As well as helping us find the literature, explaining what you were what you were taught, and any written standards that you might have that were available and applicable under the circumstance. So the next one is deviation from the standard care. Now, the plaintiff's attorneys love simple medical absolutisms. Things like if it wasn't documented, it wasn't done. It's cancer until proven otherwise, right? And there's a lot of those, and they love to kind of hang their hat on one of these little simple medical absolutisms and try and push their theory through on one of those kinds of concepts. But really, since the standard of care is really what a reasonable physician or healthcare provider would do under the same or similar circumstances, in most situations, it comes down to whether you were engaging in an unreasonable thought process. Because in most situations, the vast majority of cases involve an exercise of judgment. And then the question then becomes, well, was your judgment reasonable given the information that you had, given the little pieces of the puzzle that you had at the time that you were trying to figure out what was going on? And here I'll tell you that not every mistake is malpractice. You may misdiagnose a particular condition because based on the information you had, you thought it was more likely going to be something else than what it ultimately turned out to be. So not every mistake. It's only if that mistake was unreasonable to make under the circumstances. We particularly argue that a lot with radiologists, kind of the Where's Waldo phenomenon, where it's real easy to see some of those anomalies when you know what happened after the fact. But looking prospectively, it's much harder to do. And a lot of times what we'll do with our experts is we'll do a blind study. We'll hand them the records. We won't tell them what the case is about, what the allegations are, and ask them to decide whether this is in fact something that can, or if they see any problems with the care by reviewing the records. We particularly do that with radiologists because of that kind of that Where's Waldo kind of phenomenon, in terms of that process. So the next issue then we come to is what I would call causation. Now, in order for them to prove causation or that the deviation caused injuries, they have to prove two things: that but for your conduct, that the injury would not have occurred. But that's actually an overbroad standard because I mean you can make that stretch very wide in terms of the sequential causation element there. But what more importantly is, but it has to be but for, but it also has to be, they then have to prove that it was a substantial factor of causing the actual injury that was there. And that's really comes down to a question of whether it was more likely than not that your conduct was the cause of the actual injuries that they're complaining of. And there are, a variety of situations where that does come up. A lot of times they'll argue that your medical records were substandard and that standard of care required you to document all pertinent positives and all pertinent negatives. You failed to do so. But in most situations, even if that's true, and even if you fail to comply with your medical record keeping, it's unlikely that actually caused or resulted in any damages. For just an example. And there are a whole lot of other cases, cancer cases, delayed diagnosis of heart conditions, where we'll argue causation and it has a substantial really a substantial issue in the case. I will tell you, however, that if we cannot defend the quality of your care in the first instance, relying upon a causation defense alone, saying, "Hey, yeah, I screwed up, but no harm, no foul," doesn't sell very well with juries. I can tell you that. The only time we will do that is really when they won't let us do anything else. Where they've got us over a barrel, we did have a mistake, and then we can argue whether this particular cancer was actually going to evolve or result in the same care, the same problems, the same outcome, no matter what the physician would have done. But it's almost impossible to actually succeed in front of a jury who's going to decide most of your cases on just a pure causation defense. And they do have to prove each and every one of these. They have to prove it by a preponderance of the evidence, which is really it's not beyond a reasonable doubt. It's really whether it's more probable than not. So if you had all the evidence in favor of the plaintiff and you had all the evidence in favor of the defendant, it has to tip on that scale in favor of the plaintiff, or they don't win. And they have to prove that on every single one of these issues. So duty, standard of care, breach of the standard of care, causation, and then damages. And if they fail to carry that burden of proof, they lose, we win. And if it's tied, in most states, it actually also is results in a defense verdict as well. There are different standards in different states, but most of them are kind of, if you hit the 50%, you're equally responsible in that situation. Then you can't be held responsible. They usually have to tip those scales of justice just a little bit. So where I really kind of wanted to start a lot of this conversation is, well, what gets you sued? What's the story on that? And where I've come up with this list is a lot of information from COPIC and from the COPIC claims department, as well as talking to a couple dozen other colleagues of mine that did medical malpractice cases. And these are the most common plaintiff's theories that they frequently bring against you and accuse you of committing malpractice or being negligent in your care of your patient. And these tend to be the theories that they do. So miscommunication between providers. This is kind of the drop baton situation where, especially when a patient goes to their family practitioner sends them to the ED. The ED decides to admit them. Hospital starts taking over the care, bringing in some specialists. Specialists are involved in the care. Somebody orders a CT, but nobody ever reads it. So that, or there's just a miscommunication somewhere along those lines between the providers as to what they saw, what they did, what information that they had that the next one down the road doesn't have. Very common theory. Failure to review all the information. That always scares me in this day and age when you guys have such a vast amount of information that's there. I will tell you that you're not required to look at everything that's out there in existence that you have access to, but it's going to come down to whether it would have been reasonable for you under that situation to have reviewed and gone back and gotten that information, whether it was from the family practitioner or something that's in there, something that's on one of the exchanges, in terms of what you can do. Poor follow-up on your differential is a very common theory. In terms of what they're saying, a lot of times you may be working on what you think to be a more common or more likely situation, and it turns out to be something else. Sometimes you may have stopped and thought you had the right answer. Sometimes you just didn't get down the list far enough before the patient crashed in terms of those situations. Inaccurate charting, that's a free softball to the plaintiffs. They love to argue sloppy charting equals sloppy care. And so they really do have they like to hone in on that particular issue. If your records are inaccurate, it's a real easy argument for them to say, look, if you were this careless in the way you maintained your records, and hey, by the way, that is the standard of care, right, is to maintain accurate and complete records, which you'll have a hard time saying no to. And then just kind of lop that into, well, if you were that careless with your record keeping, geez, how careless must you have been with your care with the patient? Poor patient communication. I will tell you that a good bedside manner will help you avoid lawsuits. It will also help you get out of them earlier if there is something that we want to settle. Arrogance, ignoring the patient, not involving them in the decision-making process are things that will get you sued. And if you are not communicating with the patient the risks, the potential outcomes, if you're if you're selling them, the greatest outcome and not discussing with them the potential for a bad outcome, then you are probably going to get sued over that. That goes hand in hand with the inadequate informed consent. It's always been our position here at COPIC that informed consent is not a document, but a process. It's a discussion you have to have with your patient. It's really essential that you involve the patient in terms of getting them into the decision-making process, and that should be a joint decision-making process between you and your patient, making them sure that they are aware of what all is entailed in that. Technical errors do happen. It's a remarkably small amount. The nicked valve, the nicked artery, operating on the wrong knee. Those happen, but they are actually a fairly small percentage. They're only about 10% of all the cases that actually occur. Most cases actually come down to whether it was a lapse in judgment in your diagnosis, care, and treatment of your patient. And then finally, what I'd call the hot button issues. This includes everything that you see on daytime or what used to be late night television with all those attorney ads. Things that they're going after, all those class actions. If you happen to be involved in that, you're very likely to get involved in this into a lawsuit. Even if it was standard of care, but they're going after it and you're the flavor of the day. And so if you were involved in pedicle screws or, a lot of other issues that have come up over the years, the pelvic mesh, whatever, you can name them, anything that you've watched on either daytime or late night television with all the attorney ads. If you were involved in that, you have an increased chance of actually getting sued. Hot buttons also include anything where they can make you look like you're more concerned with getting a paycheck than you are about caring for the patient. So any upcoding on your medical bills, any kind of fraud, any kind of change or alteration to your medical record, anything that makes you look dishonest, fraudulent, or really more in for it for the buck, can actually are going to get you sued. One of the theories that the plaintiff's attorneys have been pushing for about the last 10, 15 years now is what's called the reptile theory. And the reptile theory tries to get a jury to feel that sense of danger that a community would have if there were for example, a venomous reptile running through, the community. And so they're trying to invoke that natural instinctual fear. And in this situation, you're the reptile. Okay. And they're trying to make you the reptile. So anytime that you're engaging in any type of conduct that they can turn into something that looks fraudulent, something that looks like you are committing fraud, either in billing, that you are changing your medical records, it makes this almost impossible for us to defend, particularly in alteration medical records. Don't do that. Ever. Don't ever do that. I can fight whatever the case is based on your actual real records. If you change them, I can't defend you. I will simply lose. I can tell you that right now, and we will be settling with lots of zeros after the first couple numbers. So that's generally the kinds of theories that most of the plaintiff's attorneys like to bring against you. So what's going to affect your defense? Well, quite honestly, the extent of injury, the more harm they are, the more difficult it is for us to defend you. If you've ever had a cerebral palsy baby, a lot of times those cases don't come up until to trial until the kids are sometimes 8, 10, 12, 14 even. And you see this, teenager a lot of times wheeled into the court with a feeding tube, a breathing tube, in a wheelchair. They are still wearing a diaper at 14. You can imagine how much sympathy that can generate, and the plaintiff's attorneys love sympathy. Now, we have ways of trying to minimize that, but the realistic situation is that the more harm they are, the harder it is for us to defend the case. How rare is the condition that you were treating? There's several of these that kind of that, and what was on. It was on your differential diagnosis, and you were working through it. Medical judgment. One of those medical absolutisms that defense attorneys love is the zebra, which is, when you hear hoofbeats, think horses, not zebras. And we defend a lot of cases based on that. If it's a very rare condition, you were, pursuing something that was more common. If, if it was on your differential, you were working through those and working on the most dangerous and the most common as you were working through that, but the patient crashed before we could get there. What you were doing was entirely reasonable and appropriate under the circumstances, and especially in pursuant to your medical judgment. How difficult was the care? The more complex the care is, the more juries understand that a bad outcome may result. It's somewhat surprising to a lot of juries, especially in like low back cases, where they find out that before they went into the surgery that. I've heard that said in different ways. I've had doctors tell me, it's 1/3 you'll get a better outcome, 1/3 you got no improvement in your condition, and 1/3 of a chance that you'll have a worse condition after you come out of the surgery. And so those are difficult cases. Those are hard to correct. Juries will understand that as long as they will understand it, because we're going to make sure they understand it. How consistent were the evaluations among the providers? So if I get in that drop baton situation where I've got, a family practitioner diagnosing the condition as X, the ED doc, had the same diagnosis, believed that was there. The internist or the hospitalist also was pursuing that same diagnosis. And then in the end, it turned out that this was actually an atypical presentation of a rare condition, and it manifests itself after everybody's doing that. But if what the standard of care is what a reasonable physician would do under the circumstances, then I can argue that, look, we've got 3 reasonable physicians or healthcare providers that were pursuing the same course of conduct, and that helps us prove that you were acting in accordance with the standard of care in that situation. And then documentation reflecting your interaction. There's an ancient proverb that says that the faintest ink is stronger than the loudest memory. And that is an adage that is particularly appropriate to the medical malpractice situation. Your documentation is one of the reasons that we win 90% of the cases. Now, I don't want faint ink in your documentation. I'd like nice, clear, bold, good, strong ink that explains very carefully what your reasonable thought process was of why you were pursuing what you were pursuing. Kind of linking the pieces of the puzzle that are in your head. If you can get those into your records, I can win a whole lot of cases if you'll do that. And so documentation is incredibly important. I know it's the bane of your existence, but it is also the key to defending you in most situations. So if I can get you to do that, it helps explain all of these other approaches that we will be asserting on your behalf and trying to reflect that. So let's talk about the process. If you get sued, the first thing you're going to get served with a summons and a complaint. The complaint is all the allegations they're making against you as to why you were negligent or why you committed malpractice. We have to answer that and file. We have to either admit those allegations one at a time, each allegation. We have to either admit, deny, or say that we don't have sufficient information at this time to either admit or deny. That happens in the very initial phases. It's very critical then that once you do get served with a complaint, that you immediately notify your carrier. You only will have about 3 weeks to actually respond to that complaint and get that pleading on file. If you fail to respond in that time frame, you will be defaulted. You will lose automatically, and you will not get a chance to defend yourself. So it's very critical that you make sure that you get that turned into your insurance company immediately so that they can get an attorney assigned, so that the attorney can then talk to you, gather at least some initial records, have some information upon which they can file that answer. And I will tell you that as a defense attorney, I found that even if my client believes something is necessarily true, it better be an absolute truth or I'm going to deny the allegation. Because as cases evolve, you sometimes get a lot of different perspectives. You get more information that the defendant doctor may not have had in that particular situation. So I'm going to be very careful about admitting it, because once you admit it in that pleading, then it is now an admitted fact in the case, and they no longer have to prove it. So also part of that original information gathering, the reason we have to do it very early, we have to get all the medical records. We'll talk to some of the key witnesses. We'll definitely call you in and get your whole side of the story, before we actually do the answer. And then shortly after we answer, we have to do what's called initial disclosures. And this is where we actually have to list all of the witnesses and the documents that we believe are relevant to the case. And if we fail to list those, we can supplement it as we go along, as we discover new information. But if we fail or withhold any of that information, then we may not be able to use it later in trial. So we'll do that initial information gathering, usually within the first few weeks of the case. Get the answer on file, get the disclosures off to the side, and the other side has to do the exact same thing. So they're going to have to do they're going to disclose all of the witnesses that they believe that they're going to call. At this time, it's too early to probably have experts, so the experts have a separate disclosure process later in the case. But we do have to do that, and that at least gives us the initial bulk of the documents from both sides in terms of what we're looking at. We then go into written discovery. There's 3 types of written discovery. There's interrogatories, which are written questions that you have to answer under oath in writing. There's requests for production of documents, so they can ask for additional documents. And then they can also ask for you to admit additional facts that may or may not be in the actual pleadings. So they call those requests for admission. The first 2 are the most common, the interrogatories and the requests for production. You will receive in every case. You will be involved in that because these are your answers. Now, your attorney will be, especially with the written discovery, is going to be very involved in helping you formulate how to say it. We still have to tell the truth. You have to tell the truth. I have to tell the truth as your attorney. But there are ways to say that facts truthfully that are harmful to you, and there's ways to say that those exact same truth that are less harmful, and will help you formulate those answers in that initial written discovery. And I will let you know that the breadth of discovery is remarkably broad. The standard that we work under is whether it is reasonably calculated to lead to the discovery of admissible evidence. That's the standard that judges will apply. That's the standard I have to apply when I'm responding to some of these requests for information. So if it is possibly related to an issue in the lawsuit, they can discover it. So I can get your phone records, yeah, of home and your cell phone, at least those that may have had something to do with if they had something to do with the case. I can get it. I can get into your computers. I can get into their computers, and find out exactly what's doing it. One of the things they really like to get into these days is the metadata on your EHR. The metadata shows exactly what information you looked at, how long you looked at it, whether you looked at other information or whether you didn't look at information. And so a lot of times they very frequently ask for that information as part of the case in terms of, gee, did you really spend that much time reviewing the pertinent medical records, whatever that might be, whether it was an MRI or an MRI report, a CT, past medical records, whatever it might be. We can tell exactly how and when you were in there and if you altered that record as well. So all of that information is included in the metadata behind that EHR or EMR that you might be using. Usually early in the case, and sometimes instead of actually filing an answer, we can do a motion to dismiss. These are very rarely granted. The judge has to assume every single fact alleged in the complaint is true without any further inquiry as to its accuracy. And this is really reserved for just those situations where they're asserting a legal cause of action that's not recognized in the state that we're trying the case in, or whether they simply don't have enough facts to actually show that there was any malpractice in that situation. Very rarely granted, even when there should be granted, they're very rarely granted. mostly because judges, it's very easy to appeal them. Trial judges don't like to get reversed. And it's very easy to reverse them because of that very, very high standard. But we do sometimes do that. And since that breadth of discovery is so incredibly broad, it's really important that when you first get served with that complaint, that you don't go running down the hall and talking to a bunch of the other treating providers and discussing the case. So I want you to call your insurance company. I want you to talk to your attorney. Those are going to be privileged communications at that point in time. You can tell your story to them. You can discuss it. You can do it, but keep it within the context of the lawsuit. Providers tend to have two different reactions: immediate reactions. It's not all inclusive, but some want to fall on the sword. They feel very bad. Their patient was hurt and that a bad outcome happened, and they feel guilty, and they tend to want to fall on the sword. Or the other side is the flip side of that coin. They get very angry. How dare they sue me? I'll fight them to the very death, kind of a thing. Both of those very highly emotional responses tend to have you shoot off your mouth a little bit more than I want you to. Very understandable, very human of you in doing that. But at the same time, make sure that you're not communicating with your other treating providers. We can communicate that through other defendants in the case, other defense attorneys in the case. We can keep it within privileged communications, so you can find out, what your some of the other treating physicians may have been thinking about, what they thought about the case. But don't do it when you first get that lawsuit, because all of those communications, especially if you were, the fall on the sword type, if you go run down there and say, "Oh, geez, I really must have screwed up here," they're going to find that out when we go through the through the discovery. Once we gather the information, then we start finding experts. Every medical malpractice case, almost every medical malpractice case, except for those that are kind of so obvious that even a lay person knows that you committed malpractice. Every other one, that's kind of the operation on the wrong knee kind of situation. We call it res ipsa loquitur, or the thing speaks for itself. But 99% of all cases require them to have an expert who will testify that you breached the standard of care and that breach caused injuries to the patient. And so they will be looking for experts to testify against you. We will be rounding up experts to defend you. And we do have an advantage in that. Sometimes the plaintiff's attorneys call it the cone of silence, if you're old enough to remember Maxwell Smart, like I am. But they often accuse us of that a lot of doctors won't testify against their colleagues. And they think that that's some conspiracy, usually by COPIC, that we've done it. We don't. We're not going to, chastise you or raise your premiums if you testify for the plaintiff. But they frequently think that we do, and it's really more the fact that some doctors are very unwilling to testify against the colleagues that they have to work with every single day. And so we're able to really kind of get some of the best experts to defend you. You, again, will be involved in that process. We're going to start, you yourself will be one of those experts as you testify in the case. But you will also, we'll want to know from you who you think are the foremost experts in the particular field on this particular treatment option that you were pursuing. And we'll go after them and see if we can get them to support your care. We will also put you through what we call the claims committee at COPIC, and that's where we bring in a panel under privileged, in a privileged situation. We'll bring in a panel of experts who are not involved specifically to testify in your case to kind of do a peer review on your care. And to provide us additional information and to the defense attorney of who they can do that. So we'll bring in several experts, as well as our risk management physicians, as well as our other risk management nurses and personnel, who all contribute their knowledge and information of the case. And then we'll evaluate the care as well. So that information is shared with your defense attorney and with the defendant. And it will help inform your decision whether you want to later settle, or if you want to go ahead and take this case to trial. But we'll also have independent experts, because anything that your testifying expert reviews, decides, discusses is all subject to discovery. So we keep our claims committee review outside of that process, so it's not discoverable, and keep it within a privileged context. After that, there are depositions. Depositions are really, they are verbal testimony. The other side gets to ask you questions, and as well as all other defense witnesses, and we get to ask we get to ask the patient and all of the patient's witnesses. We get to ask them questions that they are sworn to tell the truth. They take an oath. And every single word is recorded by a stenographer during that. The questions and the answers are recorded during that deposition. So you have to tell the truth. It is, again, subject to penalties of perjury, and lying under oath is actually a felony, so don't do it. We can now, that's usually a very scary part of the trial for most of our defendants, but be assured that your claims consultant, your defense attorney, maybe even your experts are going to be involved in preparing you for that deposition. We will prepare you probably longer than you actually sit in a deposition. So yeah, you may have a day-long deposition, 6-7 hours long, is not uncommon at all. In fact, it's almost uniform. There you'll spend most of a full day testifying. However, we will spend even more time making sure that you're prepared, that you're aware of what's in your medical records, what their theories are, how to respond to questions. We'll do questions and answers with you. And if you are one of those people that just is having a very difficult time with the care, we sometimes can also bring in a peer consultant and another doc who's been through this, who you can maybe touch base with on not the case itself, but maybe some of the problems you may be having. And at times we'll even bring in a psychologist to help you address and deal with those issues in preparation for your deposition, so that you can present the best case that you have. Now, what I want from you out of that is, I don't want you to be the guy that falls on the sword. I don't want you to be the doctor that is belligerent and going to fight to the end. What I want you to be is Marcus Welby. I want you to be the calm, cool professor type who's willing to educate the other side as to the reasonableness of your care and conduct. That's really what I'm looking for you in that deposition. Some of you can do that better than others. We understand that, and we're going to bring as much to bear as we can possibly do in order to make you the best witness you can possibly be. Once all the discovery tends to be done, we do sometimes take another run at trying to get the case dismissed on the papers. We call that summary judgment. That's also a very high standard. At that point, the judge still has to assume. We actually have to present actual testimony and evidence during this process, but the judge still has to believe their side of the story for every fact that they can support with evidence. The judge has to believe them, even if they wouldn't agree with it. Even if it's a small chance that a jury would do that, would decide the other direction, then they cannot grant a summary judgment. The most frequent justification for doing a summary judgment, the reason they're won the most frequently, is because the other side was unable to come up with expert testimony against you. And so we'll get the case dismissed, or even if they have somebody who says it, if we got enough inroads into their opinions that we got them to testify they really didn't know what happened, or that they that some reasonable physicians would have done what you did, then we may be able to actually get you out on summary judgment as well. Also, usually after we've at least learned what all the facts and what the evidence is in the case, you may and are very likely going to be involved in a settlement conference. That's a mediation. You're not required to settle. The judge isn't going to decide your case ahead of time. But what they will do is it gives you a chance to potentially resolve the claim short of trial before you have to go into a courtroom and put it all on the line. And these are negotiated. These are, I always thought the best description of a settlement was, it's kind of like kissing your sister. It's kind of going through the motions, but it's not what you hoped it would be. Both sides are compromised. The ultimate good settlement is when both sides are unhappy, because you actually did kind of concede different issues. Now, be aware that we will not settle a case without your consent. at least the policyholder's consent. If you're insured under the hospital policy, then the hospitals do tend to have the ability to control that. However, if it's a personal policy, then we will ask you to, and we're going to get your involvement in it one way or the other, what you want to do, and we're not going to want to go against your wishes in that situation. Certainly not against the policyholders, but we'll try and resolve the case if we can. Only about 5 to 8% of all cases that are filed actually get to a trial. Most of them are settled. A lot of them are dismissed on summary judgment or sometimes by a motion to dismiss. Sometimes we've just prepared a strong enough case that they're not willing to, that they just quit, because there are some downsides for them in terms of if we win, the other side is not required to pay your attorney's fees, but they are required to pay the costs. So the cost of expert witnesses, the depositions, court filing fees, some of those types of things. And that can often be, $50, $70, $100,000 that they may have to pay if they lose their case. So a lot of times, if they think they have a weak case, they may actually withdraw before we get that. And usually as part of a kind of a pseudo settlement, ask us not to go after attorney's fees or costs in the process, which we'll frequently do unless they were particularly obnoxious in terms of how they were trying the case. If you do get into trial, there's a very specific process. We start with jury selection. You will have a case tried by a jury of your peers, at least that's what the law calls it. You'll be lucky if they have an average of a high school education or a couple of years of college on average. If you're in a college town, they might have a PhD level jury in your case, which is sometimes good and sometimes bad. However, it's really a deselection process. You'll be involved in this. What we do is we'll put like 15 people in the box. There's additional potential jurors. Some of them will get excused for cause because they have a bias or they're not an eligible jury, or they have a very strong bias against doctors. They hate all doctors, that kind of thing, or they're very sympathetic towards the plaintiff on the other side. Very few get excused for cause, but then we do have 4 peremptory challenges, 4 discretionary challenges that we can make on each side. So we pick those 15 people. We kick off 4, they kick off 4. And what we're left with is the 7 in the middle. 6 of them will sit as a jury, usually with 1 alternate as the common. In case somebody gets sick or gets hit and gets in a car accident, we have a substitute that can sit in as that alternate without having to retry the whole case and start everything all over again. Then both attorneys get a chance to explain what they think their case is about. That's called an opening statement. It's not evidence, but it's the jury's giving them a preview of what they believe the evidence will show. They'll argue how negligent we were. We'll explain to them that we don't think that you were negligent at all. They then, because they have the burden of proof, they get to put on their case. That means they get to introduce exhibits. They get to, whether it's medical records, your phone bills, whatever else it might be, your phone records, your text messages, and they get to call witnesses who will testify as to what they know about the case. Now they get the chance to ask questions of them, but we get a chance to cross-examine. We get to examine every witness as well. And in fact, then there's usually a redirect and a recross for most witnesses as well. But the scope of questions narrows as we go down that. So they call all their witnesses, they enter all their exhibits. And then sometimes we will move for, we almost always move for a directed verdict. It's very rarely granted again. But if they have failed to prove any or present sufficient evidence on any of those elements, standard of care, breaches of standard of care, causation, or damages, if they fail to carry their burden, if they fail to present evidence sufficient to carry that burden, then we can actually win the case kind of at halftime. So even before we present our case. Again, those are rarely granted, but they are sometimes, and we sometimes narrow the scope of the types of claims that are in the case by directed verdict. After that, we get to put on our case. So we'll call our witnesses. You will testify definitely on your own behalf, as well as your experts, as well as other witnesses who may have been involved, other treating providers, the nurses, other treating physicians. And then we'll actually call your experts as well. It is possible that you have already been called in the plaintiff's case. It is possible that they can call you as part of their case. Happens every once in a while, not very often. And one of the things I want you to know is even though they did get to go first and present their evidence, lawyers are very aware of the sociological concepts of primacy and recency. Primacy, in kind of layman's terms, is the concept that people tend to believe what they hear first, and they tend to, and recency is the concept that they tend to remember what they heard last. Well, the plaintiffs in this situation get to go both first and last. So we're going to make sure that as soon as they start getting their case on, we will be asking enough questions that the jury will fully understand exactly where you're coming from during their case in chief. We spent a lot of time. By the time they get through, certainly the first witness, and absolutely by the time they get through the second one, they will know what your defense is as part of that cross-examination that we do. After we present all of our witnesses, then they do have then what we will, the jury will be read the jury instructions. That is a statement of the law that the judge will read that is the law that is applicable and applies in your case. It's what they take back with them to the jury room as being the rules they're supposed to follow. After that, after the jury's instructed on what the law is that applies to your case, and they're told what a reasonable, that the standard of care is, what a reasonable, prudent physician would do under the same or similar circumstances. They're told that they're not supposed to take sympathy into effect, but realistically they do. And then after that, the attorneys get one final chance to talk to the jury, and that's what we call our closing arguments. This is where we marshal all of the facts that have come up in trial, all the evidence that has come up that fits the theory of our case that you were not negligent and should not be held responsible under this circumstance. The other side is doing the exact opposite. They're trying to marshal all the evidence that shows that you were and are responsible and were negligent in the case. After that, the jury does go back, they deliberate. They usually have to come up with a unanimous verdict. All of them have to agree for or con, and they will ultimately fill out a verdict form, which is actually from the Latin word, it means to tell the truth. And so that's what a verdict is the truth in your case by the jury. So whether you agree with it or not, whether I agree with it or not, that will be the result of your case at that point in time. There are appeals that are possible, but you will be involved in helping us all the way through this entire process. We'll ask you if you have any, we'll ask a bunch of questions. We'll also usually turn to you and see if you have anything that you thought we should have touched on that we didn't as we're going through these witnesses. And we'll, obviously, you're not going to be involved a whole lot in the opening and the closing, but you'll know what those are going to be ahead of time. So that is a medical malpractice suit in a nutshell. I was trying to go quickly, but I still took quite a bit of time. But if you do have any questions, I'm always happy to answer them. I cannot see the chat right now. Do you have any?
I didn't get any questions. Lindsay, did you? And then we can open it up for questions. We have a few minutes.
Yep.
Yes, I did have a couple that came in. The first one here. So if you go to court, can you bring the records, or are you supposed to try and remember everything off the top of your head, or can they have notes that come with them?
Every one of those records, or at least anything that's remotely reasonable, will be an exhibit in the case. Some of them might get excluded if there's hearsay within hearsay. So some of them, so if somebody says, well, somebody else said this, right? We may have to redact that piece of it out of the records, but no, the rest of the medical records will almost undoubtedly be there. You will have the medical records available at your deposition. You will have the medical records available throughout the trial. The attorneys, the other side may actually try and get you to testify without looking at the records. And what you will be trained to do is that if rather than rely exclusively upon your memory, is saying, look, could I look at the medical record? I'd like to look at my record to see exactly, in order to answer your question. And if they say no, no, I want you to tell me what your raw memory is here. And they do that a lot in depositions, but they don't try it as much in trial. But the records are the records. And so sometimes they're trying to get you to testify inconsistently with what's in the record. But if you simply say, look, I really am having difficulty remembering exactly what I said, and in my medical record, or exactly, could I look at my medical record? They'll let you do it, and certainly in trial, because it makes them look like an idiot if they don't. That is your record of what's going to be there. And if they don't, and they still decide to be kind of jerks about it, your attorney will get up there on redirect, and we will pull every single one of those records up, and we'll clarify anything that needs to be clarified based on them trying to make you go blind. And it just makes it, they don't do that a lot in trial, because it makes them look like idiots when we get back up and say, well, let's look at that actual record that you asked to see beforehand that didn't, this jerk over here wouldn't let you look at. I wouldn't say that, but I'd certainly have that tone of voice. And we'll go back through those records, and we'll make sure that you're not missing anything or any of the details. But every one of those records will be available to you, both at your deposition as well as including ones you may never seen. And we'll as part of your preparation, we'll also go through those medical records with you ahead of time. You'll have a copy of all those medical records so that you can prepare at home, prepare at night, prepare while you're not sleeping, because you get your deposition the next day. We get it. It's a very stressful time. It's what I did for a living for 25 years. But for you, it's I win or lose a case. You guys win or lose the real case. And we get it. And we do have support systems as well that can help you through that process.
And we did have one other question. What liability is there with pre-authorization and delayed or denied care and an adverse outcome?
If it is caused by the lack of pre-authorization, you need to be careful not to try and rely upon the insurance company made me do it, or I couldn't do this surgery because the insurance company wouldn't approve it. That needs to be the patient's decision, not yours. Okay. Now you can ask for payment, obviously, because if their insurance is going to pay for it, you need to do that, but you need to put that back onto the patient. So you are not going to be directly responsible for a delay in care or any harm that results from delay from pre-authorization from the insurance companies. But especially back in the HMO days, and I'm old enough to remember when the HMOs were going crazy, and every movie was slamming HMOs, deservedly. But in that managed care environment, especially from the late 80s and 90s, when the HMOs were really trying to control the cost of medical care and denying care in the process. A few doctors did try and get up there and say, well, the HMO made me do it. It was a horrible defense. You got crucified, because what they expect from you is that you're looking after the patient's best interest, not the insurance company's best interest, or your wallet for that matter. So what you want to do in that situation is say, look, they're denying the authorization. We can do the surgery. You may be, if we do it without their authorization, you'll be at your cost. You make it available to them. Most of them are going to say, I can't afford it. I can't do that. But you're not going to be held responsible because they have declined to pay for it out of their own pocket in that situation. Yeah, we're kind of coming back around. I watch this every about 10 years, where the insurance companies start asserting more and getting more involved in interfering with the care. And we're kind of entering back into that era again as the cost of medical care keep going higher and higher.
Do we have any other questions from participants on the call? Well, I did want to just pull my screen up here real quick. As Dean had talked about, and as we see a lot here at LifeBridge, we continue to see that dealing with medical malpractice is a top reason related to stress and burnout. And so from LifeBridge, we did want to help educate when and where we can. So just as a reminder, you do have LifeBridge available. We offer free and confidential peer-to-peer physician coaching to all Nebraska licensed physicians. So you can call that confidential line listed here to be paired with a coach. And I did want to mention too that following the passage of legislation in 2023 in Nebraska, LifeBridge is currently the only program in our state protected under statute, which does mean that physicians participating in that program are protected from against discovery of participation in the program, and they're not obligated to disclose that if you are talking or speaking with one of our coaches. And I'm sure Dr. Schaefer can speak to this, is that this is one of the top reasons that individuals will call in is struggling dealing with their first one. And then finally, this program does currently remain at no cost, thanks to the generosity of our sustainability partners, COPIC being one of those. So again, Dean, thank you for being on here to help speak to that. And unless there's any other final questions from the group, I think that finishes it off. And again, just thanks on behalf of LifeBridge for coming to speak with us.
You're most welcome. My pleasure.
There's one question left in the chat.
Oh, perfect.
And it's, what options are available in the case of a biased judge?
Oh, good question. It's an adage among defense attorneys that if you have a biased judge, you better kill them, not wound them. Because if you go after them and try and get them recused for bias, you better win. Because if you don't, you really ticked them off now, and now you got a biased ticked off judge going against you. Bias has to be kind of overt. It has to be like a financial interest in this, in the situation, in the case. There are judges who are very plaintiff oriented. I've had judges who were actually, when the plaintiff's attorney didn't ask necessary questions, the judge did for them. Good old Stanstead. I love him. He used to be a plaintiff's attorney and then became a judge, and God, he made sure that they never got a directed verdict because he'd asked the questions that he felt they failed to ask in the process. There are some of those judges, you just deal with them in most situations. So we can't just say, look, you're kind of, you seem to be favoring plaintiffs a lot in these cases, and we know who they are. And we know who the defense-oriented judges are as well. It's the luck of the draw who you get in any case. It's literally a lottery in how they select your judge. And so if they have an overt bias, you know, they have a financial interest in the case, they have a connection with the plaintiff's attorney, you know, they used to be partners with the plaintiff's attorney, you know, they used to represent the plaintiff's attorney, we can sometimes get them recused. In fact, they'll a lot of times recuse themselves, sometimes they won't. But if we have good, very solid grounds to get them removed, and we can remove a judge who's assigned to your case if they have that type of overt bias, being plaintiff oriented or being defense oriented is not grounds that will succeed. And then we'd really just take off the judge. But you know, if they are, you know, again, if they have a financial interest, if they have a past social or professional relationship with the other side, whether it's the plaintiff themselves or the plaintiff's attorney, we can sometimes get them removed.
Thank you so much. And just one final thing, Lindsay had said, we do in the coaches at LifeBridge, we do take calls because we are protected under statute for people who are receiving a lawsuit. We don't want to interfere anything that you're, you know, like if you have COPIC, they have a wonderful program to protect you. But if you do need another outlet or you're not fortunate to have COPIC, please give us a call. We're happy to be that sounding safe place for you. So thank you so much, everyone. Have a wonderful new year, and we'll see you at the next webinar. Dean, thank you.
Thank you, guys.
Thanks.